I want to talk about proper contract documents and disclosures for a subject to sale from an investor seller to a consumer buyer. So more recently, I've been seeing some of the back end of these transactions, and I'm receiving the purchase contracts and the addendums and different disclosures or even lack thereof, and taking a look at them and realizing that they're not being done properly. Basically, whenever you're going to be selling a property on a subject to basis to a consumer buyer, there are a number of disclosures that need to be made to that consumer buyer. And then, second, your purchase contract should not be a modified or attempted modified acquisition contract, an investor acquisition from a consumer seller subject to. Instead, the contract should be designed for a disposition from a seller investor to a consumer buyer. And then you should have a subject to addendum whereby the consumer buyer goes through and basically acknowledges all of the terms of the financing, number one. And then second, they acknowledge all of the different risks involved in the transaction. Risk would be the due on sale clause. A risk would be that the seller investor who's taking seller carryback financing fails to pay the underlying, loan obligation and what that would look like. A disclosure on insurance, and basically making sure that your consumer buyer fully appreciates or understands what it means to take title subject to. Instead, some of the contracts that I'm seeing are basically, it looks like it's just a straight seller carryback, whereby the consumer buyer is agreeing to terms of whatever the seller investor has agreed to. And maybe they're even doing it with, using in compliance with Dodd-Frank and using an RMLO and doing all of that. But it looks like a straight seller carryback as opposed to a subject to transaction. So the consumer buyer isn't even fully aware of or appreciating the fact that there's this underlying mortgage that's out there that's going to remain against the property when they acquire it. And you need to make sure that this consumer buyer understands it, appreciates it, knows the risks, is given the opportunity to have counsel of their own choosing if they want to advise them of the nature of the transaction. Because otherwise you're going to end up, closing the transaction without those disclosures. And then if all of a sudden there's a due on sale clause issue, or the seller fails to pay the underlying mortgage, and you end up with a foreclosure situation, or the buyer is obtaining insurance, and then all of a sudden the underlying lender is not accepting that insurance and they're paying double for insurance, you're going to have issues on your hands. So you want to make sure that everything's fully disclosed up front, and that the consumer buyer fully understands and appreciates the nature of a subject to transaction as opposed to a straight seller carryback financing transaction.